today's Elections, Ethics, and Campaign Finance web conference. Today's conference is being recorded. Now at this time, I'd like to turn the call over to Ms. Erica Alba. Please go ahead, ma'am.
Thank you, Melody. Well, welcome, everybody. We are so pleased that you were able to join us on this webinar this morning. This is a rather high-tech version of how we generally do things, but we think for ease, it was easier than having everybody have to drive to Tallahassee or to Jacksonville to learn about this information. I would like to quickly introduce my co-presenters. First, former speaker Tom Feeney was supposed to be on our presentation. Unfortunately, he is in Washington, D.C. and was unexpectedly called early into a meeting actually on the Hill, so he is going to be unable to join us. Also joining us from AIF is Ryan Tyson. He is the Vice President of Political Operations and is going to give us a lot of insight on what's happening on the ground. Also joining us is a partner with Foley and Lardner, Jonathan Kilman. He has extensive experience in campaign finance law. And finally, myself, Erica Alba, Public Affairs Director and Counsel at Foley and Lardner, been active in the political environment for 20 years, both in Florida and then originally in California, former prosecutor who handled some of these cases on the other side, and hopefully will give you some insight and we'll be able to really give you kind of a roadmap on everything that's going to happen in the next probably 90 to 120 days. To start out, Florida's campaign finance reform measures, it was really consisted of 3 different proposals. You had the House bill, which was HB 569, and then that had most of the campaign finance changes in it. It had the contribution limit changes. But then you can't actually read that in a vacuum. You've got to read it with SB2 and SB4 because that both of those measures contained a lot of the nuanced language that will really affect how we deal with this on a go-forward basis. Today's presentation will kind of, a quick overview of today's presentation. We're going to start out with kind of doing a walkthrough of the new contribution limits for statewide and other candidates. They will now be different depending on what office you're running for. We obviously have the elimination of committees of continuous existence. We have new laws applicable to political committees. We have increased reporting requirements for all committees. We have some interesting rules on dual public employment for former legislators. Most of the people on this call are probably more interested in the true campaign finance provisions, but I wanted to add the former legislator limitations just because if you're lobbying or if you're employing a lobbyist, I think it's just important to know what limitations those former legislators are going to be bound by. And then last but certainly not least are the increased powers for the Commission on Ethics. And definitely after we go through all of these increased rules, Jonathan is going to provide a discussion on the increased powers of the Commission of Ethics because really that's the meat and the hammer, so to speak, to go along with all these rules. Just kind of a brief history of Florida's campaign finance rules. They were rather new to the game as far as from a national perspective. 1951 was the first time the state required each candidate to report all their contributions and expenditures. In 1973, they created what we now call Chapter 106, which is the code section that guides us through all the campaign finance and election rules. And then finally, in 1991 is when we created the $500 per person per election. And of course, we know that that limit applied to any person or entity, a political committee or a CCE. So the current structure has been in place for over 20 years. So it is rather jarring that we've actually had, a pretty significant change in the rules. Now I'd like to turn it over to Ryan Tyson of AIF, who's going to talk about how the campaign contribution limits have been changed and the key effective dates that we all need to make sure that we're aware of. Ryan?
Thank you, Erica. Good morning, everyone. I want to briefly highlight that the campaign contribution limitations, we've all heard about them, we've read about them, so I'm going to go through this really quickly because the meat of this presentation is to get some good legal authority on what's going to happen with CCEs and political committees and to highlight what Erica said, especially as we deal with ethics, because it's much different. So we're going to briefly go through a couple slides here real quick. As we know, hard money limitations haven't changed since 1991. Remember, the new limitation doesn't go into place till November 1, meaning that if you're at $500 per person per entity to any member of the legislature, statewide office, even at local level, you cannot give them an extra $500 until after November 1. Obviously, the statewide races that this applies to are governor, lieutenant governor, attorney general, chief financial officer, ag commissioner, and justices of the Supreme Court seeking reconfirmation. For those races, it's $3,000 per person or entity per election after November 1. And as we all know, governor and lieutenant governor in Florida, for those of you who are in Florida, as you know, they are the same thing. For all other races, the new caps will apply to legislative office, multi-county office, countywide, county court, circuit court, or any election conducted on less than a countywide basis. Those new max caps are now $1,000 per person or entity per election. Remembering that what has not changed is that primary and generals are considered two separate elections. We used to do 500 and 500. You had $1,000 per cycle when you combine primary and general. Now your max will be $2,000 if you were to theoretically max out. Want to highlight that candidates who decide to run for an alternative office, contributions received for the original office are counted against the contribution limits for the new office. Let me put that into English. So let's say that there's a current member of the House who is raising hard money for their re-election in 2014. And let's say that they are also running for county commission in their home county in 2016. If they decide if there's a reason that race for county office would be moved up to 2014, they would not necessarily be able to roll all of that money into the new account. If you've already got your cap, once you've met your cap, you can't double that money and roll it over into the next one. I hope that makes sense what I'm trying to say. That is a little bit of a tweak. They used to could just roll everything over, ask if you want to, they used to be able to say if you want a refund, tell me. If not, it's going into the new account. That can happen as long as you haven't already given to the other account. I hope that makes sense because it is an important difference. Contributions from political parties, I'll briefly go through this because there's only a couple people on the presentation who this will apply to. For statewide candidates, they can take contributions from a national, state, or county executive committee of political party. They're now capped at $250,000. Legislative and other candidates may receive contributions up to $50,000 from a county executive committee or a political party, and up to $50,000 in the aggregate from a national or state executive committee of a political party, effectively increasing the allowable contribution from a political party to $100,000. Remember, what is excluded from the definition of a contribution would be polling services, research services, cost of campaign staff, professional consulting services, telephone calls, etc. And last slide on this part, political parties are exempt from any contribution limit and may accept unlimited contributions. Of course, why would they limit that? Unlike many states, Florida law does not contain a management and control provision. Therefore, a corporation may contribute $500 from every incorporated subsidiary, even if the subsidiary has the same management and controlling person as the parent corporation. For those of you who are not in Florida, you'll probably know from many other states the concept of being able to have multiple entities to be able to write more hard money checks are effectively not allowed under a management and control provision. We don't have that in Florida, and that has not been changed. So for all of you in Florida, you can still bundle in plain English. Limitation on contributions of minors have been eliminated. This was a really small tweak that I remember reading when this bill was going through. They used to say that you could, if you were a minor, you could only give $100 per election. There was some concern that it was constitutionally suspect, so now minors are treated as adults. They can max out just like any other entity or person could. And with that, I will turn it over to Erica.
Thank you, Ryan. I think most of you, if you've read in the paper, you're probably aware of those new contribution limits. Obviously, November 1st is the effective date. Everybody is still operating at the $500 limit today and will be until November 1st. Secondly, the management control provision, Florida is pretty fast and loose, and we don't have to worry about that. In some states, you would not be able to do that. It becomes very complicated when your subsidiaries all get invitations to the same event, and if they're not talking to each other, you end up cutting multiple checks and then having to bring them back. So on a good level, Florida, we don't have to worry about that problem. And then just finally, just the timing of and the differentials between the $1,000 and now $3,000 limit. Obviously, only statewide gets to have $3,000. Everybody else is $1,000. So what's happening out in Florida, the campaign activity? In 2012, it broke down that there were 692 CCEs, 239 political committees, 159 ECOs, electioneering communications organizations, and 14 political committees. We're not going to really talk about ECOs today. If any of you have any questions about ECOs, I'd be glad to chat with you offline about it. But I think generally entities that have ECOs are very sophisticated and are probably directly related to either a party or a candidate and leadership. So they generally know exactly what they're doing with their ECOs, and so we don't really need to talk about that. But what's interesting in Florida, when you do an analysis of what happened in 2012, upwards of 75% of all campaign contributions were directed towards these committees, whether it was CCEs, political committees, or ECOs, or the parties. Only 25% went to candidates' actual campaign accounts. So you can tell just based upon the huge amount of money that was directed towards those committees that it is a huge part of Florida's election landscape. And it's why candidates are so dependent on these other organizations, because they understand that that's where the money is. Adding to the fact that we are, and we're going to get to this in a little later slide, we're about to, although we're getting rid of CCEs, we're about to make political committees just a vast weapon, because we're eliminating the contribution limits to them. That these are just going to become more important, not less important. The next section really talks about how Florida is now going to eliminate CCEs, and I'd like to turn it over to Jonathan Kilman, who can talk about this further.
Thank you, Erica. And just to remind everyone of the Q&A function on the website. I know some of the issues we're talking about, and as we're following along with Ryan, are a bit complex. For example, what occurs if a candidate seeks alternative office, and how that overlays with the new contribution limit. So if you have any questions about how that may play out in terms of making contributions on behalf of yourselves or the entities you manage, put that in the Q&A box, and we'll address those questions at the end. On the elimination of CCEs, I think the critical thing to point out is there will be some lingering obligations, notwithstanding the fact that CCEs will effectively be dissolved by law. And the key dates, I'll walk you through them briefly. July 15th, the Division of Elections notifies every Florida CCE of the change of law. August 1, CCEs may no longer accept contributions. It's important to remember that date, however, because unless you have another vehicle already in place, like a political committee. You may want to continue to accept contributions into your CCE up through August 1, and then use the window of time you have remaining after that to transfer any funds into a new committee. September 30th, all CCE certifications are revoked, and CCEs must have a zero balance. And November 1, all CCEs are deleted. The statutes are deleted. But briefly, you should be aware of the fact there are some lingering obligations going into the third quarter of 2013 in terms of reporting, and there will be both entity liability and personal liability for principals, officers of the CCEs. So it's critical that you pay attention to these dates. First, notwithstanding the fact that certification of the CCEs will be revoked in September, all CCEs must file any outstanding reports up and through November 1, 2013, including the reports due October 2013 for the third quarter. And here's why it matters. A PC or an ECO that is established, maintained, or controlled by an expiring CCE is responsible for any unpaid fines or penalties incurred by the CCE. So it's important that you pay attention to those dates to avoid entity liability, as well as personal liability. If no PC or ECO exists, the principal officers of the former CCE shall be jointly and severally liable for the fine or penalty. So again, sort of to walk you back through that, as of August, you're going to be prohibited August 1 from accepting contributions into your CCE. However, if you have not yet taken the steps to put in place a political committee or an ECO by that time, you may wish to accept contributions through that time and then disperse the funds in accordance with law prior to the time that the CCE is dissolved. So just take into account that you're going to be responsible for reporting that money to the state. CCE funds must be dispersed in accordance with Florida law, and again, that September 30th date is the one to remember. $500 maximum to candidates, no limits to ECOs, political committees, or political parties. And most organizations wishing to continue activity in the political process, we expect, will create political committees to replace their revoked CCEs. So we recommend that you begin planning that now, assuming you'd like to continue the process. You can either take contribution into the political committee, or again, you can transfer funds over from the CCE at the appropriate time. And again, a CCE, while it's in existence, may continue to contribute unlimited funds into a political committee. And then finally, briefly just getting into the definition of political committee, I think I'll hand that back over to Erica Alba.
Sure. Thanks, Jonathan. One of the things that I have heard from several clients is they'll say, well, we don't have a CCE, we have a PAC. And in layman's terms, they're correct, because almost in every other state, what they have would have been deemed a PAC. Unfortunately, in Florida, those were CCEs. So I think the vast majority of people who say, oh, we have a PAC, what they really mean is we have a CCE. And so we're a little bit concerned that people will not understand what kind of a account they have, and so they'll miss the deadline, or they just won't realize that they need to plan to get these things wound down. Now, hopefully, the fact that they're getting notifications from the Division of Elections will kind of trigger something, but you would be surprised at how many people we've had us anecdotally say, well, I don't have a CCE, I have a PAC. So let's say you're an entity and now your CCE is going away, but you want to continue to be part of the political process in Florida. You will probably determine that your best avenue is to create a political committee. Now, political committees, CCEs were very stringent on what you could do and what you couldn't do with those accounts. And a further slide, we'll go through a side-by-side of the differences. But for purposes of this, political committee is very broadly defined. You don't have all of the structural requirements that you had in the CCE, such as bylaws and things like that. And so a political committee is really just a combination of any two or more individuals, other than kind of a married couple with a joint checking account, who in an aggregate contribute more than $500 during calendar years. There's someone who accepts contributions for the purpose of making contributions to a candidate or a political party. They may accept contributions for the purpose of advocating defeat or the election of an issue. They might also do both. They might actually get involved in advocating the election or defeat of an issue or a candidate. And those nuances matter in what is allowed with a political committee. So let's go through current law. So current law, if you have a political committee and someone wants to contribute money to your political committee, current law says if you are dealing only with issues, there's no limit. However, if you're dealing with supporting or opposing a candidate or supporting or opposing a candidate and issues, you're limited to $500. And so if you're a corporation and you are, this is why if you're a corporation or even an organization, association, this is why you set up a CCE and not a political committee originally, because you didn't want to be bound by that $500 limit. Because if you had a few eager participants or members who wanted to give you $1,000 or $5,000, you just had no mechanism to be able to accept that into your political committee, whereas in a CCE, you could do, you had some limitations, but for the most part, you could accept any amount of money. This is current law. The legislators realized that this was a problem, and so they've changed it. And so we'll go down, the next slide will tell us what, how they're changed. So now we have contributions to a political committee. This is the new law going into effect November 1st. So we're still under the auspices of the old law until November 1st. So effective November 1st, the political committees may accept unlimited contributions from any source. Effective May 1st, so it's already in effect, you could roll over unlimited amount of monies from a CCE. So if you currently have a CCE and you are going to create a political committee, you have carte blanche just to roll over the entire amount into your political committee. But any other funds that you would want to put into that political committee, you are still bound by the $500 limit. So let's go back to a little bit to what Jonathan was talking about with the August 1st date. So effective August 1st, you cannot have a contribution to a CCE. So therefore, from August 1st to November 1st, those 90 days, nobody is going, absent giving to a political party, nobody's going to be able to give more than $500. There's no mechanism to do it because your CCE can no longer accept any contribution, and your political committee cannot accept a contribution over $500. So if you are a candidate and you are trying to raise money into your political committee, you're kind of stuck until November 1st. If you're a corporation and you do an annual fundraising contribution drive, you'll want to think about these dates because you may want to quickly do your campaign so that you can get all your money in by August 1st, but have it directed to your CCE and then just roll it over after August 1st. What could happen is if you wait, and it's not the end of the world because it's not an election year, but if you did wait and then you tried to do some kind of a campaign in September or October, you're really limited to what you can take in during that 90-day period. So it's not the end of the world, but and I'm not sure if it was a glitch or if it was purposeful. I could argue both sides, why it is a good idea or why it's not a good idea, but definitely it's something just to be aware of and plan accordingly. Because probably what you'll do is you'll probably set up your political committee, and then you'll strategically pick the date when you finally close your CCE. You may not do it all at the same time. So going on, so limitations on contributions by a political committee. So now you have the political committee. What can you do? And obviously, these are all effective November 1st. We're not talking about today. You are bound by the rules everybody else is. Statewide office, $3,000 per election. Legislative, multi-county, judicial, $1,000. The support of or in opposition of issues, that stays the same of no limit. And to another political party or an ECO, that stays the limit. Here is an interesting change in the law. Those of you who are active in the political process probably are familiar with what they call 3-PAC committees, which is a PAC that is designed for the purpose of jointly endorsing 3 or more candidates. That used to not be bound by the same contribution limits as if you were giving to a candidate. That is no longer the case. You will have to, those contributions will have to be limited in the same way. And for those of you writing down, you've got Code Section 106.021 was the section that talked about 3-PACs. And so they just tried to make it consistent so you can't dump a bunch of money into those accounts. Permissible and prohibited activities of political committees. If we can say anything over and over and over and over today, it is that political committees are not the same as CCEs. And I think there's a lot of banter going around that, oh, well, you just create a political committee and then everything else goes the way it was. And that's really not the case. In many ways, political committees give you broader powers and ability to be politically active, which may or may not be a good thing depending on where you're coming from or your client's coming from. But there are some rules, and I just, we can't stress enough that, really pay attention. They're not the same. Political committees can contribute to any candidates. They can give to other PCs, ECOs, parties. And like I said before, they really will become the committee of choice for most corporations and organizations. Here is where, if you don't pay attention to anything else we say today, really pay attention to this. A political committee is prohibited from giving, either directly or indirectly, any gift to a reporting person or procurement employee or a member of his or her family. Who is a reporting person? Well, we know them as legislators, legislative staff. The procurement employee, we'll learn later, is those who have kind of control over $10,000 a year or more in procurement contracts, or any member of their family. Now, this is all new law. We knew that reporting persons you're not supposed to give them gifts, but now they've created a new section to really talk about the fact that they don't want that happening. And they further go on to say a reporting person of procurement employment or a member of his or family is prohibited from soliciting or knowingly accepting any gift from a political committee. And the value of the gift is irrelevant. And you might say, okay, well, we're used to not giving gifts to legislators. This is really not new law. But they've redefined gift. For the purpose of this code section for political committees, they have redefined gift. And so now gift means any purchase, payment, distribution, loan, or disbursement of any money or anything of value that is not primarily related to contributions, expenditures, or other political activities. Well, what does that mean? Let's say that you are, we'll start out with an easy one. You're a lobbyist and you have access to your client's PAC, or maybe you have your own PAC, and you take a legislator to lunch because you're going to give him a $1,000 check or a $500 check. You can probably pay for lunch with your PAC or your political committee. And if he wanted to, the reporting person had his own political committee, he could probably pay for his lunch and your lunch from his committee as well, because you're going to lunch and you're giving him a check, and it's and any reasonable person would be able to explain that lunch, the primary reason for that lunch was to give the political contribution. What if we made the facts a little bit harder? What if we have going on a fishing trip, and we want to take a legislator on a fishing trip to meet our clients, and we're going to give him $1,000, but we're going to have him fly down to the Keys and get on a boat all day long, go out to the out and about to wherever you go when you fish. I'm a fisherman. And you're going to be on this fancy boat, and you're going to have a nice lunch, and at that point you're going to give him $1,000. Now, is that primarily related to the a political activity or a contribution? The answer is I don't know, because they have not defined what primarily related is. Is that nice fishing trip, is that primarily related to getting that $1,000? Maybe the legislator just wanted to go and have fun in the sun, and the $1,000 was kind of an afterthought. Maybe not, but I think it's a gray area. Now, the law does not give the Commission on Ethics regulatory ability to write regulations for this section. They've given it to them for another section to make their electronic process better, but not on this section. So we're not going to be able to rely on regulations that come out of the division or the Commission on Ethics. We may be able to rely on some legal opinions, or maybe we'll have some clarifying language in legislation next year. But I just want everybody to be aware of, when you are paying for an activity for a legislator with your political committee, make sure that you really are secure and that it's primarily related to the contribution expenditures or political activities. Now, most of you, if you have CCEs, you're not used to paying for that kind of stuff anyway. You already know the law that you're not supposed to pay for anything for reporting persons. So you might say, well, I'm just going to keep doing what I always do, which is nothing. And that's certainly fine. Where it might get dicey is on the candidate side, because now candidates are no longer going to have CCEs either, and legislators are not going to have CCEs, and they're going to create political committees, and they're going to have to be very, very careful on what they pay for themselves, because remember, if their political committee is giving them or their family anything, you are still governed by this gift definition. So they're going to have to be very, very careful on their end. And I'm not sure we have any legislators on the call today, but if you run into any of them, just make sure that they're being very careful about that. And the penalty for violating this is a penalty of 3 times the amount of the gift. And what's important is it can be assessed against the giver and the receiver. So the committee can be assessed as well as the reporting person. Moving on. So this is kind of a side-by-side of what CCEs could do and political committees could do. And as you see, there was quite a long list of limitations for CCEs. CCEs were not allowed to do any electioneering communication unless they registered as PC. They could not make independent expenditures. They had to operate in accordance with a written charter or bylaws. And 25% of their income had to be from dues or assessments payable regularly from their membership. So yeah, you could have somebody who gave you $10,000 big check, but you had to offset that. That couldn't ever be more than 25% of the whole income. Political committee has no such limitation. They can, I think Ryan will talk about his interpretation of political committees in a minute, and he kind of has a funny visual that he'll give you. But this is the wild, wild west now. They're free to do whatever. They don't require bylaws, And so they can be set up without bylaws. We tell our clients that they need to think about how formal they want to create their political committees, not necessarily because they're worried about getting in trouble, but just from an internal perspective, it protects them. And let me give you an example. CCEs were not allowed to do any expenditures, independent expenditures, or electioneering communication. Political committees can. So let's take an example. Let's say the Senate comes to Organization A that has a political committee, and they say, can I have $50,000? We would like you to give $50,000 to the party. And you say, no, I can't really afford that. I can give you 10,000. And they say, well, okay, but what we're trying to do is we're really trying to buy this airtime, or we're trying to put out this mailer in this legislative district, a Senate district in Miami, and we need $50,000 for it. And when you're like, well, I'd love to help you. We're going to give you $10,000. So they may go away happy or unhappy, but that's the way. That's current law. That's kind of how the conversation goes today. Now, new law, they call you back and they say, you know, we love your $10,000, and we're going to, I've got 4 other people that want to give $10,000 too. And what we would like to do is we'd like them to write a check to your political committee, and then from your political committee, you would buy the airtime or pay for the campaign flyer. That becomes a very difficult conversation because some organizations may not want to be quite that down in the weeds with political activity. And if you have your bylaw, if you determine up front, listen, we really just want to run our political committee the way we ran our CCE. We don't want to become this hyper politically active entity. Then it behooves you to be a little more formal when you create your political committee. Write out your bylaws that you're not going to do things like that, because that'll protect you from having that uncomfortable conversation with the Senate or the House for that matter, where that you say, I don't want to get involved in this Miami Senate race because first off, what do you lose? But then also, I don't need the media calling me asking me why Organization A just bought $50,000 worth of airtime in Miami. My organization does not need that kind of free press. This will protect you. So just know that political committees can be very dangerous. It's like driving a very powerful sports car, which is really cool, but you better know what you're doing or you're going to just get in a big wreck.
And Erica, if I could real quick.
Yes, please join in.
The analogy that I've been telling my members is we used to have these CCEs that were, for lack of a better term, kind of like jet fighters, like F-14s. And now, in essence, the way that I interpret it, what we've done is we've now created Death Stars. And the problem is that a lot of folks are pretty sloppy, and I don't mean a lot of the people who are running these things casually, if you would. They didn't know how to drive either one. And now you've got this big Death Star that can do so many other things. So it's really, we try to really impress upon you, there are things that both can do, but it's just not correct to say it's the same thing. It's just not.
And Ryan has just a good point. Just protect your organization, protect your clients from getting into situations where they didn't want to be. Yes, their political committee is going to have the power to do all of these different types of activities. And if I'm the Senate president, and this is, I've never had a conversation with the current one, so I'm just using the title, not the person at all. But if I'm the Senate president and I need something to happen in Tampa the 2 weeks before the election, and I don't really want to know where it's coming from, it would be fun to have an organization who signed up to use their political committee to do all of that for me. But that doesn't mean it's good for that organization. So if you're a lobbyist, do all you can to protect your clients, and if you're an organization, please just make sure that, eyes wide open when you get into it. Okay, now we're getting into truly the accounting boring part, but unfortunately very critical part of the presentation, campaign finance. effective November 1st, political committees and ECOs are going to have to file more than 3 times the number of campaign finance reports to the Division of Elections. Under current law, all of these entities, including CCEs, which now will go away, they must file quarterly reports with the division disclosing all contributions and expenditures made during the quarter. Effective November 1st, this is going to monthly. They'll require monthly reports, disclosing all contributions and expenditures. Then you're going to switch to weekly, which is going to occur the 60th day immediately preceding the primary, and you'll have weekly reports until the 4th day before the general, and then you go to daily, and so and that'll commence the 10th day immediately preceding the general election and each day thereafter. If you are in an organization, let's say that you're Walmart, you have a huge accounting department that has someone who could probably make this their, at least a third of their time could be doing these reports, and that's okay. If you are not in a position or you're in an organization that doesn't have that kind of internal accounting expertise, I cannot stress to you enough that I recommend that you get some outside help for that. And this is in no way a plug for our firm, because it would not be cost effective for you to hire a big law firm to do this. But there are CPA firms. There's good ones in Jacksonville, Tallahassee. There's a great one in Tallahassee. There's one good in Tampa. There's probably one in Miami too. I'm just not aware of them. It's not expensive. Have somebody be in charge of these reports. The quarterly report is mildly annoying. Monthly report is a lot of work, and so just be careful of what's happening, especially if you operate your political committee in a little more active way than you did your CCE. You just need to be careful. But I can't stress enough how I think it's always a good idea to have a pair of outside eyes watching, and they will know the dates like the back of their hand, and they don't have to keep counting backwards from election day. What happens if you file an incomplete report? Well, the division, they have to accept it, but they accept it on what's called a conditional basis. Then they will notify your treasurer, and you will have 7 days to file an addendum. If you don't file the addendum and giving them all the information, it'll constitute a violation. Now, not all of this is new law. A lot of this is current law. However, because in a later section Johnson's going to talk about the increased powers of the commission, I just think it's worthwhile to kind of go through all of the ways you can get in trouble, because now there is mom and dad or the judge are at the end of the line who can actually get you in trouble, whereas before, nothing really bad ever happened. You can get a waiver of your reporting requirement, and again, if you're going to use this, again, unless you have someone who is a full-time accounting person, an expert, or if you don't have that, make sure you have some outside help, because you don't want to use a waiver and then not a correct waiver. But let's assume that you think, okay, I can have a waiver. You can do that as long as either a political committee or a candidate has not received any contributions, made any contributions, or expended any reportable funds. And then you don't have to do it every month, although when you finally gear up and do the report again, you've got to account for all that time that is in between where you didn't talk about it. Okay, what are the penalties? Again, these are not really new law, except for the likelihood of being enforced against just went up a lot. $50 a day for the first 3 days, $500 per day for each late day, but not to exceed the total receipts or expenditures for that month, whichever is greater. This is actually current law, but I want to make sure that they all know, and that is fines incurred by candidates must be paid from personal funds. They cannot be. It's not a campaign expense. It's not a business expense to have messed up your reports. And again, like I say, this is all current law, but the mechanisms for enforcement were not really set in force before, and now that they are. Responsibility for the report. Again, this is existing law, which is the candidate or the candidate's treasurer. They must certify the correctness, or the political committee's chair or the treasurer must certify to the correctness, and any person who willfully files a false or incomplete report commits a misdemeanor. So they are really starting to put some teeth behind this. This was always the law, although I don't think anybody ever got afraid before. This kind of brings us to the end of our reporting requirements. I tried to run through this because it is, in some ways, watching paint dry. It's very dry. But it is important, and like I said, I can't stress enough, if you are just a small organization and you're going to try to do these monthly reports on your own, at least until you get really get into it and get a comfort level with it, reach out to one of those accounting firms who, and they're very inexpensive, and get some assistance so we make sure that you do it all correctly. Jonathan, we can talk about dual employment by public officers.
Sure. Thanks, Erica. And I'll be relatively brief here as well. I don't know that anybody on the call would be directly affected by this, except to the extent that you're currently involved, particularly in local government, where you're either hiring or creating positions. But I think a lot of us who are involved in the political process, both as lawyers or not as attorneys, just involved perhaps as lobbyists or even corporate officials, would be well served to understand that there are some obligations now with respect to dual employment by public officers, and whether real or perceived problem with those in elected office using that office to further their careers through public jobs. So the definition of a public officer is any person elected to state or local office, or for the period of her candidacy, any person who is qualified as a candidate for state or local office. The requirement or obligation here is a public officer is prohibited from accepting public employment with the state if the public officer knows or should have known that the offer of employment is being offered for the purpose of gaining influence or other advantage based on the public officer's officer candidacy. And I think the key words there that make this complicated are the word knows or should have known. So there's a knowledge requirement there for the public officer that they had an understanding that they were being offered a position to gain influence. So to the extent that you are in a position to assist a public officer in obtaining some employment that could be construed as being offered for the purpose of gaining influence, I think it's important that you avoid implicating yourself, whether through conversations, through emails, mails, etc., that imply in any way that the position that's being offered is for the purpose of gaining some sort of influence or other advantage. The restrictions in particular on the next slide are that the public officer may accept public employment only if the position was already in existence or was created without the knowledge or anticipation of the public officer's interest in the position. And I think an example of that might be something like a pre-existing position in a state attorney's office or some other public office that existed prior to the person being in elected office. Second, the position was publicly advertised. Third, the public officer was subject to the same application and hiring process as other candidates. And finally, the officer meets or exceeds the required qualifications. I think the red flag on this issue would be a circumstance where someone is serving in the legislature and lo and behold, a new position opens up in government somewhere that never previously existed, that they are brought in to occupy it. And then you look at some of those other factors, whether it was advertised, what the process was, their qualifications, etc. But a red flag will certainly be if the position did not exist prior to their taking on the employment. Now we're going to talk about the powers of the Commission on Ethics, which have been expanded by the new laws. So now there's an expansion of the types of organizations that can refer complaints to the Commission for Investigation. Governor's Office, U.S. Attorney, Florida Department of Law Enforcement, Florida State Attorney, and a sworn written complaint by any person. And I think if you look at those organizations, they all have their own mechanisms for determining when a complaint rises to a level that it needs some action. For example, the U.S. Attorney's Office, FDLE, State Attorney's Office are certainly familiar with that. The Governor's Office, on the other hand, has not traditionally been one where that sort of prosecutorial discretion has been held. And again, this is not for direct prosecution by any means by the Governor's Office, but I would think that they would be hard pressed to not forward on some complaint they received for purposes of investigation by the Commission. So they may be kind of roped into this process a bit, or any of these other agencies that previously were not as involved. The Commission does not have the authority to initiate investigations absent a referral or complaint from one of those entities, and they may only investigate referral upon an affirmative vote of 6 Commission members. So there are some restraints here, but there's certainly an expansion. What makes this perhaps more relevant for many of the people on the call is the Commission now has the power to investigate lobbyists for the following 4 reasons: failure to register, failure to submit a compensation report, if you make a prohibited expenditure, and knowingly submitting a false information in any report. And this making a prohibited expenditure is particularly relevant in the context of the broader conversation. If you recall, Erica read through the definition of gift, which now includes a provision that any purchase, payment, distribution, loan, advance, transfer of funds, or distribution of money or anything of value that is not primarily related to contributions is defined, expenditures or other political activities, is defined as a gift. And again, we're somewhat in the dark at this point in the sense that until some opinions are issued or some enforcement occurs, some of the parameters that will apply are unknown. I think Erica gave some examples with respect to proportionality, and of course, there's always the ability to give in-kind contributions in connection with fundraising. But I think, at least on the surface, this expansion creates the possibility of greater enforcement by the Commission and a greater scrutiny of whether or not the activities that you might have traditionally considered within the context of a CCE to be normal to perhaps be unacceptable under the new mindset with political committees and the expanded powers of the Commission. And then the potential penalties, of course, if the Governor and the Cabinet find that a violation occurred, the penalties are a prohibition from lobbying for 2 years, reprimand of the violator, censure of the violator, or a fine of not more than $5,000 against the lobbyist, the firm, and the principal. So as a corporation, you may also have some corporate liability if a lobbyist acting on your behalf engages in some of the prohibited activities. And we can talk about any questions on those subjects at the end. Erica?
Thanks, Jonathan. Just kind of going back to some of the things we're talking about reporting, getting some of we're starting to stream through some of your questions. One of them was, if a CCE is given $500 to a PAC, can the new PC give them $1,000? I would argue that if it's the same, if it's, let's say it's the Foley and Lardner PAC, and it's just been rolled over from the Foley and Lardner CCE, probably you are limited to $1,000 total. That would be the spirit of the law. Now, that being said, nobody has ever litigated yet whether a CCE, an old CCE and a new PC, even if they're owned and operated by the same kind of management control, whether those are two complete separate entities or whether they're one entity. And that's probably one issue that will be needed for clarifying legislation. I would say the spirit of the law is that you would be limited to $500 for $1,000 total. I'm not sure that the letter of the law says that, however. Another question, currently you can't contribute money up to a federal PAC from a state PAC. Will this stay the same? And the answer is yes. Now, they did not change anything having to do with this. Was the requirement for an annual report also revoked, or will one be due? The legislation did not affect, did not talk about the annual report. It is our position that there is still one necessary, but to be honest with you, probably check with your accounting people because they will know more details on the reporting dates for those than we will as they change. And how does this affect the corporate entity covered on the division of corporations versus division election side? Not sure. I'm not 100% sure what you mean by the question. However, the division of elections does have authority over anybody who has a CCE, or not a CCE, a political committee, or any one of these accounts, or who basically engages in the political process, which is why they can go against the principal if a violation has occurred. So moving on, just a quick thing on gifts and honoraria. It expands the current gift ban to also prohibit state vendors who do business with the reporting individual's agency from giving any gifts. Vendors had not been included in the gift ban prior to now, and so on a go-forward basis, they will be. It also clarifies what is a procurement employment for purposes of a reporting requirement. And that is, I think I mentioned it earlier, but you're a reportable employee only if you exceed or expected to exceed $10,000 in purchasing during a year. And then finally, I just kind of wanted to brush over this. This would really only affect you if you're interested in legislation and you are active in the legislative process. You might find this of interest. SB2 created some voting conflict provisions for legislators. They're prohibited from voting on any matter that would inure to their special private gain or loss. Now, nobody has defined what special private gain or loss is, but sometimes they would be obvious, but sometimes they wouldn't. So that's still a gray area that we'll have to figure out what it means on a go-forward basis. But legislators need to be aware that there is this provision, and so they need to take a little bit of special care. For example, if they have a job in a particular sector and there's legislation affecting that sector or company. It allows a public officer to create a true blind trust, and then you can avoid any of these conflicts of interest. There's some limitations. We're not going to get too far into the weeds on this. There's some limitations on who can run the blind trust. You can't have your wife run the blind trust. But if it really is a true blind trust, then you can you've essentially avoided any of the conflict of interest provisions. What's new is that you have to file a copy or at least a notice of the trust with the commission. So you can't just conveniently come up with the trust after the issue has already been raised. And then finally, the law now includes members of Enterprise Florida as public officers governed by the conflicts of interest rules. Clearly, they deal a lot with trying to bring companies in, and there's some competition issues that go along with that. And so the legislature thought it was a good idea to include Enterprise Florida. into the conflict of interest rules. So that is basically our presentation in a nutshell. I know it's a lot of information, and a lot of it doesn't apply to each of you, but I wanted to kind of go through some key important takeaways. First, as Ryan said, contribution limits have not gone up until November 1st. If you're asked for a contribution, you're limited to $500 until that day. CCEs are obviously going away, and you must they can't take money after August 1st, but you have till September 30th to completely dissolve them, and they must have zero balance by September 30th. If you're unsure about what to do with the money, obviously if you create a political committee, you can easily roll that over into your political committee. But if you decide, hey, I don't want to do that, I just want to make it go away, then Florida law does outline what is permissible. And if you have any questions about that, call. We're happy to kind of give you the list of what is permissible or not permissible. Starting November 1, all PCs and ECOs, we didn't talk about ECOs today, but they're included, are required to file monthly reports, not quarterly reports. Political committees cannot pay for recreational or other expenses of a reporting person absent the expense being primarily related to a campaign purpose. If you are in the campaign political sector, or if you do that kind of activity, you need to remember the terms primarily related and have at least a working idea of what that means, so that you can know what you can do and not do, because you don't want to just inadvertently get yourself in trouble. As Jonathan stated, the commission now has investigative authority over PCs, ECOs, lobbyists, and I think most importantly, principals. PCs, ECOs, lobbyists, we all kind of, it's assumption of the risk. We're involved in the endeavor, and we kind of take the risk when we get involved in political activity. Principals sometimes at least have some belief that they're kind of operating at this $100,000 or the 100,000-foot level and may not be exposed to anything. And the commission can go after principals if they think it's necessary. And I think that's something that if you work for a principal, you have to be very careful of. But, equally important, if you represent a principal, if you're a lobbyist and you represent a principal, you have to make sure that you do everything you can to protect them, to make sure that they're not exposed in any way. So it probably means that you interpret primarily related, at least for your own purposes, in a very narrow fashion, just to keep until we really know what that's going to mean. You can't be too conservative in that area. And then finally, the penalties for violations of the campaign finance laws have been increased, and so the fines have increased. And like I say, the potential persons or entities exposed to these finance laws have also been increased. So that's important to know. We've kind of gone through a lot of information. The three bills contained a lot of information. There is still more in the ethics bill that we did not talk about today. It mostly affects legislators or reporting persons types. So I didn't think that this audience necessarily wanted to have a whole hour of ethics, but it is critical, and things will change. And like Ryan said earlier, as long as you understand that political committees are not the same as CCEs, and in many ways they have broader powers, but with these new gift definitions, there's also some stricter rules. I think you'll be fine, but go through this with eyes wide open, be very careful, reach out to any experts that you know to ask for advice. And also, if you really don't hesitate to reach out to the Division of Elections, shoot them a letter and say, what do you think this means? Not sure that they're going to have to decide, because they're about to be inundated with a lot of questions. They're going to have to decide internally how they handle it. Are they going to start issuing opinions? Are they going to hold them and then try to get a legislator to sponsor clarifying legislation to kind of clarify all those questions? They'll have to internally decide how they handle that. But at this point, it's always better to be safe than sorry. Melody, I think we're ready to open it up for questions. Jonathan and Ryan, do you have any closing statements you want to make? Or?
I think you covered the key issues, and I think some of the questions will be helpful if we have any. Yeah, I think, Erica, the point you made and Ryan made it, is that political committees certainly can do a lot more than CCEs, but you need to be very cautious in whether you want to create an entity that has the ability to do so much without having bylaws in place that would create some reasonable limits for your own protection as a corporation, political organization, or lobbyist, and that lobbyists now have a new layer of effort as well as their principals in engaging in activities that might now fall outside the lines with respect to the new language, primarily associated with fundraising. And until we have a better sense of how that's going to be interpreted through enforcement or opinions, I think we need to err on the side of caution. I think traditionally we've said if you use your common sense, you should be okay. I think under the new regime, we should say use your common sense, but err on the side of caution, because we simply don't quite know yet what activities will be deemed to be illegal under the new language.
The last thing I'll add before we take questions is it's probable there'll be a lot of unintended consequences with these PCs over the next couple of years, and I just highlight from the side of working with political entities, ECOs, doing all of the hard money, soft money coordination projects that I ask you to really highlight the fact that these are not the same as CCEs, and I would urge you, as we are urging our members, utilize your bylaws in these new political committees to prevent yourself from getting into trouble, from getting into things that you don't want to do. Most of our members here at AIF, they only need a political committee set up to write hard money checks. They don't need to do anything else. So make it to where you can't do it. There's a lot of ways you can protect yourself, and we're happy to help you get through these next several months and several years in any way that we can.
Ryan, why don't there's a couple of written questions that we can go through, and this one is right up your alley, so I'm going to have you answer it. The question is, it sounds like political committees can now fund communications supporting or opposing candidates. A political committee that does this, are they limited by any contribution limits? Also, are they bound by similar rules that ECOs are bound to as it relates to communication?
The answer, if I'm understanding the question correctly, I don't know, Z, if there's a way that I can see the questions, or if you can email them to me, it'd be easier to read through them other than hearing them. If I'm understanding the question correctly, the first answer is yes, that the political committees can expressly advocate for the election or defeat of an opponent. They're not limited in how much they spend on that. The key is coordination. You're not allowed to coordinate if you're doing expressed advocacy. That's the difference between that as opposed to an ECO. An ECO is not expressly advocating for the election or defeat of a candidate. Unlimited money, expending unlimited money, however they can coordinate. That's the key is that the PCs cannot coordinate if they're expressly advocating for the election or defeat of a candidate. Does that make sense?
It is. I mean, we're not going to be able in this short amount of time to really probably give you an answer that would you should take to the bank as far as, oh, now I can do X with Y money. But definitely, yes, you are now able to fund communications supporting or opposing candidates. Now, there are rules, and like I say, Ryan outlined some, and there are more, but
this is where,
so you want to get advice. But yeah, yeah, it is.
What I would advise at this point is that's where, this is where you have two options. You either go and hire a really good firm, and there's a lot of good law firms in town who help with defining whether or not a communication is expressed advocacy or not, or if it's electioneering. This is where you have a choice. If you want to be in that world, then you need to hire a firm. You need to be ready to have a lawyer on board to help you navigate those waters. If that is not something you want to do, it's why I said in the presentation, prohibit yourself from doing it in your bylaws is probably the safest bet, because as was given during the presentation, be ready during primaries especially for consultants and folks that are running campaigns to say, you know, we could really use your help on this project. It's just a mail piece. It's just a radio ad. And what I would tell you from the practitioner standpoint, there's never just anything. And it's why you should have, if you're going to, my advice is from the practitioner standpoint, housing and association is, if you're going to utilize this new ability to be a Death Star, you've got to have good legal counsel to help you differentiate between the two. You have another question, Erica?
Sure. Another question is PC, a PC, is that the same as a PAC? And I think PAC is something that, that's kind of a layman's term. We all use it. I have a PAC. You know, this company has 3 PACs. And I guess the technical answer is no, because a political committee can do, first off, a PAC doesn't necessarily exist in the state of Florida. We have them by different names. But if I were to compare what, you know, a PAC can do in some other states, a political committee can do a lot more. It's much broader. It has a much broader authority and much broader powers than just your quintessential PAC that you may have, you know, maybe you have a federal PAC, or maybe you have a California PAC, that kind of thing. So it's broader. Oh, this is a good one. And Jonathan, this is a good one for you. Please talk about how these changes impact contributions to a legislator's favorite charity.
Sure. So to the extent that there's always been a separate set of regulations with respect to a legislator soliciting funds for their favorite charity, the new statutes didn't expressly alter those laws. However, because we now have greater oversight by the Commission and this new provision relating to directly relating to fundraising activity or contributions, it's possible, and we don't know this yet, it's possible that frankly, I think it's likely to be challenged by the person who's receiving the request or some person who was offended by the request to suggest that a solicitation for such a contribution would fall under the new law. I don't believe that it does on the surface of the new law, and it's not expressly prohibited. If that comes about, we'll see it through enforcement action or an opinion. I think one of the issues we've got to resolve is there's no rulemaking authority that's been created by this new statute allowing for the division to adopt rules that would clarify some of these issues for us. And so we're going to have to wait for either enforcement or seeking formal or informal guidance from the division or from the Commission. That said, I think to the extent that traditionally there's been a separation for solicitation of charitable contributions, it would likely remain separate and continue to occur. But there's always been a difficult balance in that area of the law, and if someone wanted to challenge it under the new provisions, they could, simply by virtue of the fact that there are new restrictions in place.
Next question says, does a political committee have the requirement of ongoing dues revenue like the CCE did, or can contributions to the PC be made at any time? Brian or John, either one want to take that, or you want me to take that?
My understanding is the dues requirement is now gone. We used to have so many percentage of our contributions had to be dues, and my understanding is those are all now gone. Correct, Jonathan?
Right. That always applied just to CCEs, and nothing in the current law has changed that.
Correct.
Okay. Can the new political committee have the same name as the old CCE? There's nothing in statute that would prohibit that, so it can. Here's one. It says, if I give a $500 donation to a candidate campaign account, hard money, in second quarter of 2013. And now November 1st comes around. Can I catch up for primary and give another $500 plus another $1,000 for the general election under new law? And the answer is yes. You can, as soon as November 1st comes around, the limit is now $1,000. So whatever amount you're under $1,000 for the primary, you can do $1,000, and you can do another $1,000 for the general election. Now, if we were in 2014 and November 1st was coming along, you couldn't backdate it to try to help them out for something that happened a few months ago. But because we're in 2013 and the primary has not occurred, yes, you can do that. I guess we can open up that's all the written questions, so I guess we can open up.
I just got texted an interesting question, and I'm not sure if Jonathan wants to take a stab at this or you, but the question just texted to me was, can the bank accounts stay the same? If somebody closes down a CCE, their bank is at SunTrust, can they just change the name, or do they have to open up a new bank account?
That's not defined by statute, to my knowledge, but here's what I'd say is, typically when the bank allows you to open an account, it's associated with the tax ID number for a particular entity, and I would suspect that the financial institution would require you to open up a new account associated with that ID number. Whether they're able to kind of roll that over to a new ID number or new organization, I don't know. I don't think it's addressed in the statutes, and so I'm not sure we're in a position to give a clear answer today. If whoever has that question wants to follow up, we can do some follow-up work, but I don't know. I don't have the answer unless Erica has a different sense.
No, I would just add to that even if the bank allowed you to do that, I would certainly make sure that you are able to really delineate when one ended and one began, so that you don't get caught up that your new funds get tagged with old CCE title. So even if you're sitting in the bank and you do it all at once, and okay, now we've closed down this, we all count to 10. Okay, now we open it up as this. Just make sure that there's a clear line where it is. So if you ever had to prove that up, that you'd be protected and be able to do it. I suspect that Jonathan's right. I suspect that the bank, for their own reporting purposes, are going to want to completely change one out and change it over. Do we want to go to live questions? Do we have any?
And ladies and gentlemen, to ask a question over the phone lines, please press *1 on your telephone keypad. We'll go to our first caller.
Hello. If in line with the question about the bank account, do we need to get a new federal ID number for the PC?
That's a good question. Again, it's not specified in statute, but it seems to me that when you're going to be creating a new business entity, that it would be something that you'd be required to do. I don't have the answer to that. Frankly, I think a CPA might have an instant kind of handle on that issue, but I suspect that because you're creating a new business entity, you're going to need to get a new ID number, and then that would likely, in interacting with your financial institution, require a new account. And I apologize if there was more to the question. Please continue.
No, I mean, so we clearly need some lead time to be able to do that then.
Yeah, I think, and I think it's a good question. I don't, again, sitting here, I don't have an answer to it because it's not outlined. It's not certainly outlined expressly in the new statutes. But traditionally, when clients have started new entities in the past, it's typically triggered a filing for a new ID number, and that being the case, I think you're going to want to make sure you have some lead time and you're set up to do that. It's not a complicated process if you've done it before, I'm guessing, to get a tax ID number. It's fairly quick, but and painless, but it's something you probably are going to want to do, if nothing else, just to create a kind of clean slate for a new entity when you're closing out the financial records of one and starting a new one.
Thank you.
And actually, I'm getting, and although I'm getting some information now from a CPA that's Abby, who's participating on the in the webinar. She's advising that you can keep the same EIN and same bank account. So that's the one where, again, I think you probably want to, if you're using a CPA, you want to cooperate with them on that. I think it would be easier if you could keep the same EIN and account. Again, it's not something that I have experience in working directly with the bank and setting that up. But if Abby's suggesting that it's something that's easy to do, and she's also letting me know right now that she verified this with Christy Bronson as well. So I'm assuming that's correct. I apologize. It's not something we researched or thought through before the webinar. But Abby's been in this space for a while, and it's advice that I would likely follow. Thank you, Abby, if you're listening.
And once again, ladies and gentlemen, *1 if you'd like to ask a question over the phone lines today. And we have no questions in the queue.
Okay. Well, thank you, everyone, for participating. If you have any questions, please, feel free to reach out to Jonathan, myself, or Ryan. We really appreciate that you've taken the time to kind of learn about this. It's a lot of moving parts, at least through November. We're all going to be trying to learn at once and try to make sure that we do everything as appropriate. So thank you very much, and have a great day.
And ladies and gentlemen, that does conclude today's call. Thank you all for joining.